Hello, everyone. Thank you for joining. It is my pleasure to welcome you all to today's webinar on liquidated damages in construction disputes, a comparison across multiple jurisdictions. My name is Vivek Sharma. I'm an associate at MRP Advisory, and I have the honor of moderating today's discussion. Liquidated damages are an important and critical component of construction contracts, designed to compensate for delays and breaches without the need for prolonged litigation and arbitration, if I may say so. However, the enforceability, interpretation, and judicial intervention concerning liquidated damages vary significantly across jurisdictions. Today, we are privileged to have an esteemed panel of experts from various jurisdictions. Starting from India, we have Mr. Adarsh Ramakrishnan, partner at MRP Advisory. From Dubai, we are joined by Sadaff Habib, who is an independent arbitrator and the founder of Equanimity Arbitration. From Oman, we have Abdulredha Al Lawati, founder of ALC Lawyers Counsels. From Saudi Arabia, we are joined by Foram Majmudar, my apologies, who is a senior associate at Mahassni & Co. And from the UK, we have Kort Egan, barrister from Gatehouse Chambers. I would like to extend my gratitude to our distinguished panelists for taking the time out to join us today. Their expertise will provide valuable perspectives on the complexities of liquidated damages in construction law. Before we begin, a housekeeping point. We encourage audience participation. Please submit your questions in the chat, and we will address them in the Q&A session, which is to happen at the end of the webinar. Without further ado, let us begin our discussion. I would like to first invite Adarsh to share his thoughts on Indian law. So, Adarsh, if you could tell us the legal position on application of liquidated damages in construction disputes as per the laws of India.
Thank you so much, Vivek, for organizing this. So in India, liquidated damages are governed by a statutory provision, the Section 74 of the Indian Contract Act. It was drafted way back about nearly 150 years ago, so it has stood the test of time, although there has been a lot of debate on how it is to be applied. And it's certainly in cases of construction disputes, there have been varying interpretations of the statute. So Section 74 provides that if a contract is breached, the party suffering from that breach should be entitled to reasonable compensation, but not exceeding the amount stipulated in the contract. The primary issue has always been, for the courts, has always been in relation to what constitutes reasonable compensation. Because the easiest way for anybody to attempt setting aside or attempt to or try to make sure that the LD clause is not enforceable is to attack whether the compensation stipulated under the contract is unreasonable or penalizing in nature. So we post-independence after 1947, we've had several decisions which have stipulated that LD clauses should be reasonable, should not operate as a penalty, and all of these cases led to a point where the Supreme Court had to come and clarify that for construction contracts, and especially, the courts can award whatever amount that is stipulated under the clause without actual proof of actual loss if the sum represents a genuine pre-estimate of damages. And the courts have also stipulated that if actual loss is capable of being proven, then the courts insist on evidence or some form of evidence to be presented and some burden of proof to be discharged so that a party that is claiming compensation can demonstrate that they have suffered some loss. Now, in the construction context, the party that usually seeks LD is usually seeking LD on account of delay, although there have been cases where LDs have been tried to be operated for defects or other performance issues. So here where we have noticed in India, LD clauses are fairly standard in construction contracts. There's a financial impact due to delays and defects. And courts in India have held that in cases where the quantification of loss is difficult, LD clauses can be enforced. A party does not have to specifically discharge a heavy burden of proof, and it will promote certainty, it will reduce litigation and costs of litigation. So the courts have enforced liquidated damages provisions unless parties have been able to successfully demonstrate that the LD clause is extremely high, extremely unreasonable, which there are very few instances of courts having set aside and refused to enforce LD clauses. That's it from my side.
Right. So again, like the issue of reasonable compensation does come out, and even the Indian Contract Act provides for it under Section 74, as you stated. So could you tell us, like in a scenario where the liquidated damages have been specified in the contract, then how do courts ensure that the interpretation of this provision balances interest of both the parties that have entered into the contract?
Okay, that's a good question. So, first of all, in one aspect, you're right. There is a peculiarity because the term reasonable compensation appears in our statute, and that sometimes results in a possibility of various arguments trying to hold that one clause is reasonable, one is not. There is no set percentage that any court has been able to fix to determine that this would be the percentage of the contract price that would be considered to be reasonable and enforceable. But there is often the courts have alluded to the possibility of a reasonable test to ensure that there is fairness. So in this regard, what the courts considered is um, issues of proportionality to ascertain that the LD amount must reflect the actual risk and potential loss rather than being purely punitive and uh, purely penalizing in nature. So we have seen cases where a single lump sum fixed for all types of breaches without any clear indication of how it would be applied would be termed unreasonable. This was a very interesting case in 2009 between the Steel Authority of India Limited and a contractor. But then again, it's very important to know that the burden of proof would shift to the party that is seeking to set aside the LD clause or try to diminish the impact of the LD clause to prove that no loss has occurred or that the amount stipulated in the clause is unreasonable and extremely high. So the other thing that the courts have done in the past and which does not see which is peculiar to India, or at least from in my experience peculiar to India, is that they try to ascertain in cases where there is delay, they try to ascertain how much of the employer's actions have contributed to delay. So if there is a possibility for a contractor to demonstrate that the employer has overwhelmingly contributed to the delay, then the courts can read down the LD clauses and also try to accommodate the contractor's claim for prolongation costs in relation to the employer's claim for LD. So both of them have survived wherever employers have contributed to delay. It's been difficult for them to seek the full LD amount.
Right, right. And as we know that, as you said, that burden of proof is very important in such contracts and in such disputes. We've also seen that in India, the courts have been very adamant that you have to prove your loss, even if the amount has been stated. But there have been situations where in construction contracts, we have found that it says that the actual loss need not be even proven. So how does this requirement impact the drafting and enforcement of such clauses in construction contracts?
Yeah, in construction contracts, for the employer to be able to claim LD for delay, it's a hard task to prove exactly what costs they have suffered or losses they've suffered. One easy way would be to demonstrate all the overheads that they have, all the project management consultant or the engineers costs that that they had to incur, or if they had any agreements in place for the commercial operation of whatever they were setting up, then the finance costs of that they had to incur for that. That would be one way of putting evidence on record to demonstrate actual loss. Um, if if it is difficult to quantify, which courts have held time and again, the courts may enforce the LD clause without any strict proof. So this brings the question of what should be the key considerations while drafting such contracts. So I think the most important aspect is to clearly define the LD triggers. I mean, if you have to identify which milestone the non-completion of which would result in the triggering of the LD delay, delay for LD delay being triggered. And if there are any, if it is in relation to defect, then identify the technical parameters on which they would be triggered, so that would be easy for people to understand what is the how the LD claim is being operated. You cannot just keep a very blanket LD clause, which we have seen courts set aside them if they do not specify, if they do not demonstrate what sort of breach results in the LD clause being operable. Then the other aspect, which lots of contractors and employers have started doing, is they have also agreed that the LD amount that has been stipulated under the contract reflects a genuine pre-estimate of damages. That's always helpful, but fortunately, because of the latest round of judgments, I feel like there is no need for you to specify that the court that this amount represents or reflects a genuine pre-estimate of compensation that is likely to be incurred by the employer against the contractor, or for that matter, by the contractor against the subcontractor. So yeah, that's it.
Thank you. Thank you so much. Thank you so much, Adarsh. And now that we know that the position in India is this, we can now move on to the another jurisdiction that we have is the UK. And maybe we can ask Kort now. So Kort, if you could tell us the legal position on application of liquidated damages in construction disputes as per the laws of England and Wales.
Thank you. Thanks for the question and thanks for having me. So in terms of England and Wales, I would say that liquidated damages clauses are a common feature of the vast majority of construction contracts. The standard forms that are predominantly used here, the JCT and the NEC forms, they include liquidated damages provisions. And that's not just in large scale projects, even in minor works projects, I would expect to see liquidated damages clauses, though obviously the rate is likely to be relatively low in those clauses. Now, I slightly feel like the odd one out today because as an English barrister who practices all over the world and spent a lot of time, particularly on cases in the UAE, this liquidated damages point and the court's approach to it is a real point of difference in terms of English law. Because where there's a liquidated damages clause and the contractor or the subcontractor has failed to complete on time, they are prima facie liable for the liquidated damages, either by way of action or by deduction if there's an express power, or by way of a set-off. There can be no inquiry into the actual loss suffered and no adjustment of the amount stipulated. Now, obviously, that doesn't mean that there's not a defence to the liquidated damages claim, because I'm sure we're going to come on to talk about penalty clauses, and there are often other defences raised like waiver, etc. But in my experience, I would say that where the governing law is English law, parties tend to spend more time focusing on the facts, i.e., who actually caused delay and the extent of delay, and arguments like waiver and non-compliance with condition precedents, rather than seeking to challenge the actual liquidated damages clause itself.
Right. So Kort, you began by referring to JCT and NEC contracts, and you told us that they also contain a liquidated damages provision. And then you also said that it varies. It doesn't vary in the sense that even large scale projects have it and even small scale projects have it. So could you tell us, like, to what extent can courts intervene to adjust the amount of liquidated damages clause, especially as you said, if deemed a penalty?
Yeah, so as I say, again, I am the odd one out, but there could be no inquiry into the actual loss suffered and no adjustment of the amount stipulated. So if you do actually want to challenge the substance of the clause itself, then that would be by virtue of the contention that the clause is a penalty clause. Now, the Supreme Court considered the proper principles when it comes to penalty clauses in the Cavendish Square and Makdessi case. That was the 2021 case. Now, the test was formulated in slightly different ways by the various different members of the Supreme Court. But probably for expediency, I'll refer to Lord Mance's formulation, as I think that requires less detailed explanation. And what he said when it comes to the relevant clause is that it's necessary to consider first whether, and if so, what legitimate business interest is served and protected by the clause. And secondly, whether, assuming an interest exists, the provision made for the interest is nevertheless, in the circumstances, extravagant, exorbitant, or unconscionable. And it's worth noting at the outset that it may not just be the financial costs of an overrun that fall to be considered, because reputation and standing could also be a relevant consideration, because, as we're all well aware, if there's a late opening of a significant project, then that can cause real serious reputational damage to an employer or a main contractor. But also, as I've said, words such as extravagant, exorbitant, and unconscionable, they're quite strong words, and they obviously demonstrate that in practical terms, there's going to have to be a marked discrepancy between the liquidated sum in the relevant clause and the innocent party's legitimate interest in enforcing the obligation to complete on time. And a further point is, well, even if it's actually demonstrated that the clause is a penalty clause, well, what happens then? And under English law, the employer or the main contractor basically has an option, because they may either rely on the claim for the penalty, in which case they can't recover more than the actual loss, which can be proven up to the amount of the penalty, or they can ignore the penalty and just claim liquidated damages, unliquidated damages. Now, in practice, that's actually likely to lead to the same outcome, because it seems fairly unlikely that you're going to be able to both demonstrate that a clause is a penalty clause, but then you're also going to be able to demonstrate that you're entitled to damages in excess of the sum that has been held to be a penalty clause. So in those circumstances, you are likely to just end up arguing for the unlimited damages. So even if the penalty clause is proven and made out, then that's not going to be the end of the story. But again, as I mentioned before, I would say under the law of England and Wales, we more often see arguments like waiver. I can say in very recent experience, I've just come out of a case that I was working on for about 4 months, where it's a multi-million case, and the dispute was effectively whether the parties had either expressly agreed or whether by conduct an agreement had been reached, or there was a waiver or a stopple, that the liquidated damages clause wouldn't be claimed for a specific period. And we see those sorts of arguments quite frequently. Or, as I also mentioned, condition precedent arguments, because in our JCT forms, for example, there are condition precedents that effectively require 3 different documents or notices to be given in a specified sequence. And if they are not, you fail to comply with the condition precedent, and the ability to deduct or claim liquidated damages doesn't arise. And as I say, I think it's those type of arguments and the factual arguments that tend to arise more than the penalty clause arguments, probably, because, as I say, the bar when it comes to demonstrating that a liquidated damages clause is a penalty clause is actually quite high.
Right, right. And as you said, Kort, that in many of these construction projects, reputation does form a very important aspect. We have, as you were also referring to, a scenario where the project starts late. But how about a project which gets terminated? So if you could tell us, what is the effect on liquidated damages provisions in case a construction contract has been terminated before the work got completed?
Yeah, so again, this was actually a live issue before the Supreme Court considered the point in a case called Triple Point Technology and PTT. Now, the answer to the question ultimately depends upon the wording of the particular clause, because parties could expressly agree that a liquidated damages clause continues to apply post-termination. Now, in my experience, that's very rare. I can't say I've seen that yet, but obviously it is theoretically possible. But what the Supreme Court said, and in particular Lady Arden's judgment, with which Lord Leggett and Lord Burroughs agreed, they helpfully summarise the position in terms of English law when the judgment states parties agree a liquidated damages clause so as to provide a remedy that is predictable and certain for a particular event. Here, as often, that event is a delay in completion. The employer does not then have to quantify its loss, which may be difficult and time consuming. Parties must be taken to know the general law, namely that the accrual of liquidated damages comes to an end on termination of the contract. After that event, the party's contract is at an end and the parties must seek damages for breach of contract under the general law. So if I was to wrap that up in a nutshell, it's basically subject to the wording of the particular clause, liquidated damages can be claimed up to termination, and then it's the general law and your claim would be an unliquidated damages whereby you'd actually have to demonstrate the loss suffered.
Right. Thank you. Thank you so much, Kort, for sharing the response and your insights to the position in the UK. Now we'll move ahead and we'll go to Sadaff. And so Sadaff, if you could tell us about Dubai, like what is the legal position on application of liquidated damages as per the laws of UAE?
Thank you, Vivek, and thank you for having me here today. It's interesting because now we're crossing jurisdictions entirely into the civil law jurisdiction. Of course, having heard from my common law colleagues, Adarsh and Kort, on their respective jurisdictions, I think before I set out the legal position on liquidated damages, it's important to understand what it actually means for the UAE to be a civil law jurisdiction. Now, what that basically means is that it's a codified, the laws are codified in the UAE, and it's heavily influenced by Egypt's legal system. Now, as a civil law jurisdiction, obviously its courts are civil law as well, and we have a three-tier court system here, starting with the Court of First Instance, Court of Appeal, and Court of Cassation. As I explain further about liquidated damages, you'll understand why I'm referring to the court system as well. Now, in terms of the law that is applicable in the UAE, it is captured in Article 390 of the UAE Civil Code. And Article 390 is a very interesting one because the first part of Article 390 obviously allows, which is the general consensus when it comes to liquidated damages, it allows parties to agree on this fixed amount of damages in the contract before there is a breach of contract. And, like my colleagues have said, that this is very common, obviously, in construction contracts. In the UAE, we see the most common standard form of contract is the FIDIC Red Book, and liquidated damages is captured in subclause 8.7. Now, the second limb of Article 392 it's very interesting because it empowers the courts and, of course, arbitrators where there is an arbitration at the request of either party to reassess the amount of fixed liquidated damages in the contract to reflect the actual loss suffered. Now, of course, this is 360 opposite to what court set out as the position in England and Wales, because this power is prescribed in the UAE Civil Code. I will stop here because I think we'll explore this further.
Right. And a very interesting point that you brought, that there are both common law and civil lawyers in this webinar, and I think there's majority of civil lawyers present. So considering the codification of laws that you were talking about, so we know that there's Article 390 of the UAE Civil Code, and as you said, it allows judges to adjust agreed liquidated damages. So how does this judicial discretion impact the predictability and enforcement of such clauses in construction contracts?
So I would say at the outset, as much as this authority and this power is given to the judges, they use it rarely and they use it reluctantly because, of course, you are, as a judge or as an arbitrator, what that would mean is that you're varying the parties' agreement. But that is not to say that the courts will not use or exercise this discretion if the situation requires it. Now, say, for example, you have a construction contract, and let's say that typically, what happens? Yes, you have a delay. The contractor has not completed the project on time. The employer decides to levy liquidated damages and makes this claim. What the contractor could do is to ask, because for Article 392, for the discretion of the court to be triggered under Article 392, it's important for the contractor to make this application. It's not a question of, just sitting there and sort of making your defense, but you need to actively seek it, which is something that I have seen as an arbitrator where they will not apply for this, even though they might have been granted the extension of time and they could have used that in order to apply for a decrease in liquidated damages. So anyway, coming back to my point, the contractor would make this application to reduce the liquidated damages to reflect the actual loss. Now, in that scenario, what happens is that the contractor needs to prove what the actual loss was and why they're making this request. And some of the things they could say is, for example, I had a scenario where, as an arbitrator, the employer had been granted an extension of, sorry, not the employer, the main contractor had been granted an extension of time under the main contract, and yet the main contractor was seeking liquidated damages under the subcontract. So in that case, the subcontractor actually came back and said that, no, this extension of time covered, regardless of whether there was a delay on my side, the main contractor did not suffer damages under the main contract, and therefore the LDs should not be applied. Now, in that scenario, obviously, that means that the actual loss suffered is not, it's not justified. So, as much as we can say that, yes, this judicial discretion could potentially create some sort of uncertainty, in my view, the way I look at it is that it's almost like the courts have given the parties freedom of contract, but at the same time, they will step in to correct an injustice, to avoid a situation of unjust enrichment. And I would stop there.
Perfect. So Sadaff, very interesting, and thank you for sharing the insight about the case that you handled. And I found that to be really interesting because then the main contractor could not have got LD. Was not levied LD by the employer. So similarly, the subcontractor was also not. That's a very interesting point that you brought up. But talking about actual loss, could you maybe elaborate a bit more on it? And could you tell us the significance, of demonstration of actual loss and enforcing or challenging liquidated damages under UAE?
Sure, Vivek. And I thought the best way to do that would be to go through 2 UAE court judgments, because then you can see practically what the considerations are and what elements came up. So in the first scenario, we have, again, it's a subcontract agreement. And the subcontractor is arguing that no liquidated damages are due to the main contractor because the main it's similar actually to my scenario, come to think of it, because the main contractor did not suffer harm because of the subcontractor's failure to perform. Now, this case went before the Union Supreme Court, and the Union Supreme Court is the highest sort of federal court in the UAE. And what they did was they overturned the lower court's award of liquidated damages to the main contractor because they found that the proof of breach was not enough to award these damages under Article 390. Now, what the court also said was that an award of liquidated damages can be rejected if the debtor shows that the creditor did not suffer harm because of the debtor's breach. So this goes back to the points in this case, because they saw that it was not, yes, okay, the subcontractor is in breach of their contract. Yes, they failed to perform. But that breach did not cause the main contractor to suffer harm under their contract with the employer. So in this case, the court decided that this non-performance was not the cause of the penalties, and the court held that the main contractor did not suffer this type of harm, which would actually warrant an award for liquidated damages. Now, in the second scenario, which is not stepping outside the construction zone a little bit, and it's actually a commercial case, where there was an owner of a billiard hall who was claiming 320,000 dirhams as liquidated damages from the supplier, who had promised to provide 20 snooker tables by a certain date. Now, the contract provided for liquidated damages at 500 dirhams per table for every day of delay. The supplier said yes, they accepted, yes, okay, I'm delayed delivery of the tables by 32 days. The owner as well, at the same time, who's making the claim for liquidated damages, there was a court-appointed expert, and before the court-appointed expert, they said that the revenue, the monthly revenue that was being generated by the billiard hall was between 50,000 dirhams and 52,000 dirhams. Now, mind you, this is the actual revenue that's coming in, whereas the liquidated damages claim is for 320,000. So what the court decided in this case was the court of first instance, which is our first tier of the court, they relied on the expert report and they awarded the owner 79,000 dirhams in damages. So it's still less than the liquidated damages in the contract. Now, it went to the second level, the Dubai Court of Appeal, and what the Dubai Court of Appeal did was they reduced that 79,000 to now 50,000 dirhams, because remember, the owner had admitted that the monthly revenue is actually 50,000, 50 to 52,000 dirhams. So you can see what the court is doing here, because they're adjusting the liquidated damages to reflect the actual harm that the owner would have suffered in terms of loss of his business. Now, the final court, which is the Dubai Court of Cassation, they upheld the Dubai Court of Appeal's decision and awarded and amended the liquidated damages amount fixed in the agreement to reflect the actual harm of 50,000 dirhams. So you can see here that what the courts are actually attempting to do, it comes back to the point that I'd earlier made about unjust enrichment. So as much as obviously, you know, it's a discretionary power, they would be reluctant to vary the parties' agreement. But if so required, I mean, think about it, especially in this case, 50,000 dirhams and you're claiming 320,000 dirhams. It's a huge difference between the actual loss and the liquidated damages amount. I'll stop there.
Thank you, Sadaff, for sharing the two cases with us and explaining it in detail. Very helpful. And now we'll move on to the next jurisdiction, and which is Saudi Arabia. And we have Foram with us. Foram, so now if you could tell us what's the legal position on liquidated damages in Saudi Arabia.
So thank you for that question, Vivek, and thank you for having me here. So the legal position on this is pretty similar to the UAE. And like I want to clarify, like firstly, under Saudi law, the broad concept of liquidated damages has always existed. It stems from the Sharia principle that is well known, that there be no harm nor cause any harm, you know. And the sort of recent developments with the Saudi Civil Transactions Law, or CTL, it reflects this principle. Even under CTL, the sort of primary remedy that courts usually tend to prefer for any breach or failure in performance is more or less specified performance. But where specific performance is not an option or not sufficient, we have compensation damages, which are then looked at by courts, and especially common, of course, in construction contracts. The sort of important development and departure from previous jurisprudence is, of course, that claims for lost profits, what was considered before as merely possible harm, can now be awarded. So in my experience, current cases where we have seen some parties seek to recover lost profits based on CTL, the parties are still being subjected to the usual high burden of proof, especially in the context of whether the damages could reasonably have been anticipated at the time of contracting, And in my view, this is where pre-agreed liquidated damages should become even more common for commercial parties. I advise caution in this, because the change that we have been seeing is not without restrictions, as we'll explore further, I'm sure.
Sure. So let's explore further, Foram. And we do understand there's Article 178 of the Civil Code in Saudi Arabia, which essentially permits parties to specify liquidated damages in construction contracts. So could you tell us about what are the key considerations for contractors and employers when they draft and enter into these clauses so that they could be enforced later and they are also, in a way, reflective of potential losses?
So the most significant takeaway, practically speaking, commercially, is that liquidated damages are absolutely not a given. And from experience, this is sometimes controversial for international parties, especially American parties, because in some jurisdictions in the US, liquidated damages may also be recovered if actual damages are not proven. So while there is an obvious concept convergence, even in Saudi, in my view, Saudi courts are much more paternalistic, and therefore commercially this needs to be considered much more. Given, of course, that there remains no binding requirements on courts, there remains the risk relating to interpretation from one court to the other. So generally, my advice has always been to consider linking the liquidated damages to the harm, and if circumstances permit, for the clause to include explanation of why or how the liquidated damages represent the harm caused. Much Adarsh talked about in his explanation of the parameters to consider. And at all times, I always also say that please consider that if the liquidated damages are viewed as a late payment of fees penalty, then the courts are going to look at it unfavorably and essentially unenforceable.
Right. So let's delve a little further into it and looking at the civil code, of course. If you could tell us that, and we understand Article 179 is there in the civil code, which provides and outlines specific limitations. One of them is like the non-applicability of liquidated damages if the obliger proves no damage was sustained by the obligee. So could you tell us, Foram, how might this provision influence the burden of proof in construction disputes?
So to answer this question, I want to take a step back and sort of say how a claim of compensation really works out in the real world, right? For any claim of compensation, and this has been the practice thus far as well in Saudi, the claimant really has to prove three things. A, that there was a legal duty that was breached. B, that the breach was the proximate cause of the damage. And C, the damage itself. I have not yet seen divergence from this practice. What liquidated damages help in doing is, of course, helping the claimant in number C, wherein she or he may argue that the compensation should be granted per the pre-agreed, if indeed the pre-agreed liquidated damages represent a reasonable estimation of the damage that has been caused. What CTL 179 does is make some room for the defendant to come in and argue that in the circumstances, the LDs, the liquidated damages, are not applicable because A, the claimant had not suffered any harm, and the claimant is essentially trying to penalize the defendant, or B, the LDs are excessive in the circumstances. In A, the burden would likely be on the defendant alleging no harm, and in B2, the burden may be upon him to show either how partial performance or how the pre-agreed liquidated damages would be unjustified in the circumstances of that particular case. Now, of course, the real issue here is that neither excessive nor partial performance are clearly defined or explained, and thus become fertile ground for disputes. But the bottom line, in my view, despite the constraints and limitations on liquidated damages, variation from liquidated damages will be exceptional, as the evidentiary burden on the defendant is going to be high. And therefore, it's generally advisable for parties to consider all of this in negotiations and drafting of the contracts in the coming time.
Right. Thank you, Foram. And this is very important as well, like irrespective of whichever jurisdiction you are having a dispute in. When you pointed out the C point that, the damage has been indeed suffered. So the contractor who's or the person, plaintiff, is going before the courts or the arbitration tribunal, if they're trying to seek that, it really helps them to prove that the damage has actually been suffered. So invariably in all jurisdictions, and in almost all disputes, the other party disputes it. But yes, it's advisable to include such things in the contract itself. So thank you so much, Foram. Now we'll move on to our last speaker, Mr. Abdulredha Al Lawati. Thank you, Abdul, for joining us today. And so could you tell us about the legal position which is there in Oman, and how liquidated damages are disputes are resolved around it?
Thank you, Vivek, for inviting me to this webinar and organizing this webinar. And it's always a pleasure to join you. Basically, I would continue the discussion which my colleagues have from the GCC have started. Basically, Oman is a civil law country where most of the transactions are mainly codified, and the parties are bound with these codes and royal decrees that are promulgated time. Mainly, when we talk about liquidated damages, we have to understand, first of all, the law that is regulating the contract agreed between the parties. Mainly talking about liquidated damages is something that we always need to deal with the civil transaction law, which is a codified law regulating the entire transactions between the parties on any activities, whether civil activity between individuals or commercial activities between or involving companies overall. Now, talking about the liquidated damages in construction disputes, I have to introduce, the civil transaction law from particular position where the construction is mainly a part of contracting section that is introduced in the law, in the civil transaction law, and it was identified clearly as a contract where the contracting party or the contractor is obliged to manufacture something or carry out any work for a payment. That means that we are talking about an achievement of intention. We are talking about an achievement or full performance of work in order to get the payment. However, the liquidated damages is something that is casually or exceptionally agreed on in case of any breach in these contracts. And basically, the assessment on the application is built on certain elements that the party or the aggrieved party claiming this liquidated damages should satisfy. So these three elements are the most common elements, I would say, in Oman and the GCC overall, where we have to classify these elements while we are submitting our claims before any judicial authority such as courts or arbitration tribunal. When we talk about the settlement of the liquidated damages amicably, that means that the parties are sitting together, having their own amicable meetings and discussions in order to satisfy and clear the liquidated damages. But normally, liquidated damages means that there are some disputes going to be filed between the parties. And that means that we are now going to introduce the main elements, which are starting from the harm, where there should be a harm against the aggrieving party, and it's resulted from a defaulting party, which is considered as a second element. However, there should be always a link, which is as a third element, there should be a link between the default and the harm in order to have a successful damages, liquidated damages claim. When we talk about the harm, we are talking about the exact damages affected the aggrieved party based on damages that resulted from the defaulting party. And I have to say that the courts in Oman, basically on some old precedents, have confirmed that the harm is the first element that is always should be considered in order to assess any liability, which means that the harm is a public interest matter where by having this such existing harm, we can always move with the case. And when we have the default, it means that we are introducing the defaulting party, we are showing the evidences of the defaults, whether it's based on law or based on breach of contract, because the civil transaction law is prioritizing the contract always. So in order for a judge, for example, to assess the liquidated damages, the judge normally review the contract first. Based on the law, the contract is the main source of regulation between the parties, and then the law will be applied as a second source in order to assess the claim. In addition to that, the link between the default and damages is a third element, which is a very fundamental element, because if we don't have this link, if we don't create, as lawyers, I'm talking about lawyers in this situation, if we don't introduce this link, that means that we are having unsuccessful case or unsuccessful claim to be submitted before the court normally. Nonetheless, the court have also introduced some extra elements that always need to be considered, where we are talking about a right or a legal position that are subject to the claim or subject to the dispute, basically. And as a second element, the precedent has confirmed that it's not merely a legal position that we are discussing about, but we are talking about a breach to this legal position or the right which the aggrieved party has suffered from. Like, for example, if the party has been deprived from this claim, then there is, a breach mainly to the overall, if the party was deprived from his right, that means it's a breach mainly. It's a breach to the contract or to the relationship between the parties overall. And these, to be frank, these positions or these precedents have played very valuable contributions in drafting the civil transaction law, by the way, because the civil transaction law was promulgated in Oman only in 2013, which means that the regulator have reviewed the previous precedents and ensured that these valuable precedents, which played very fundamental role in assessing the claims overall, must be at least adopted in the law as a matter of principle, so the parties in future can draft their contracts or agree on their dealings in accordance with the customs. Don't forget that when we are talking about the precedents are not an obligation for the judge to adopt, but it's a main of source where it can be reliable in order to assess the claim, basically. So basically, the legal position, when we talk overall about the legal position on the application of liquidated damages, we have to consider the contract mainly. and the contract is a fundamental source of relationship, then basically we follow the law in order to reach to the assessment of the liquidated damages in the construction disputes.
Right. So, Abdul, thank you for sharing your insight and explaining it in detail to us. We also note that, as Sadaff had pointed out earlier, that there is a lot of similarity between civil law countries, which are especially based in the Middle East. And we understand, like as Foram was pointing out, there are 3 elements to be proven in case liquidated damages are to be claimed. Similarly, the position seems to be very similar in Oman as well, especially on the emphasis of there has to be a link which needs to be established by counsels. So if we could move on to the next question, and I'm conscious of the time, and I understand that we are nearing the end of the webinar. So if you, Abdul, if you could just tell us the discretion which is there, and as Sadaff had pointed out, that there is judicial discretion in Dubai as well. So we understand there's Article 267 of Omani Civil Code, which allows courts to adjust pre-agreed liquidated damages. So could you tell us, like, how does judicial discretion impact the predictability and enforcement of such clauses in Oman?
Look, basically, I have to tell you one thing. Article 267 of the Civil Transaction Law is falling in the conditions and the articles which are regulating the contracts overall. Don't forget that when we are talking about the construction disputes or the liquidated damages in construction disputes, it's regulated by special clauses in the law itself. So Article 267 is coming as a general rule where it gives the judge the right to adjust the liquidated damages. But I have to say that the court is prioritizing the contract, and the contract, as I mentioned, is showing an intention of the part of the contractor to achieve the targeted performance, the targeted achievement that needs to be done for the employer, for example. And the employer is obliged to pay whatever has been agreed on. In case of any breach, the breach consequently will be subject to some damages. And these damages are covered in the agreement, which means that the court at the first step follows the contract, ensure that the contract is not breaching the public order, does not breach any royal decree, does not breach any law. And if you go, especially in the contracting section, Article 628 states that the contract shall determine the nature, the type, the quantity, methods of performance, validity of payment, which means that the court is obliged to go through the contract first, and it shall move and assess the claims as per the contract. Taking into consideration other articles such as Article 629, 631, where it says that the contractor must carry out the obligations as set out in the contract and in accordance with the customs. When we talk about the customs, we are talking about some parts which are giving the court to little bit to interfere, and this also depends on how the opponent party does defend himself or herself from the liquidated damages. We have to say also one more important thing, that we have come across recently against in cases where we filed it with the liquidated damages. I'm grateful the court did not deviate from the main assessment of the liquidated damages. Why? Because the court also have the right to appoint experts, to call for witnesses. So the court will not go directly to any pre-adjustment until it utilizes the means of evidences in order to reach to the main assessment that we are claiming, basically. One of the cases that I had recently, very recently, we filed a case, we claimed some amounts, and the opponent did not take it seriously and did not come. And our compensation that we have claimed as liquidated damages were quite high, and we did not take it seriously because we thought that the judge might reduce it or might reject it. But fortunately, the court accepted all our claims and immediately awarded to us, which means that the court doesn't want to play with the contract. If the contract was in compliance with the law, it does not breach the public interest, and it was also reasonable, because reasonability is very, very important also in dropping the claims back on the bench, basically.
Right. So congratulations, Abdul, for your victory. And thank you.
Thank you.
Thank you for sharing your insights with us. I'm conscious of the time, and we have received a few questions. And maybe, Sadaff, you can take a crack at it, because it says, what challenges arise when enforcing liquidated damages clauses in international arbitration versus litigation in national courts? So maybe, Sadaff, like, if you could share your experience with us.
Sure. First of all, are you able to hear me clearly? Because there's some construction going on around me, and we're having a construction webinar.
We are able to hear you clearly.
You're
Yeah.
able to hear me? Okay, all
Yeah.
right. Now, in terms of enforcement of liquidated damages, I'm not quite sure what the question is getting at, because see, if you are if the arbitrator has, say, for example, if the tribunal has awarded liquidated damages, let's assume the tribunal has awarded liquidated damages. When it comes to enforcing the arbitration award before the courts, the process would be the same. And if it's a Dubai-seated arbitration, then the federal arbitration law would apply. And under the federal arbitration law, you cannot challenge the merits of the case. So the fact that the tribunal has decided to award liquidated damages, that would still continue. Now, if the situation is the opposite, let's say the tribunal reduced the amount of damages to equal the actual harm that is suffered, again, the pathway to enforcing the arbitration award where it's a Dubai-seated arbitration would be the same. The difference between, obviously, the litigation, if you have a construction claim before a court and a construction claim in arbitration, is that obviously with arbitration, you have to follow the process through right until the arbitration award is rendered, and then go ahead and enforce it. So there is that added process. Obviously, if you have a construction case before the courts, then it can go through the three-tier, the court system, with the final judgment coming from the Dubai Court of Cassation. So that's the difference in terms of the process, but I hope that answers the question.
Right. I hope so too. So thank you, Sadaff, for answering that question for us. And I would like to extend my thanks to all the panelists who have joined us today. And for sharing your invaluable insights, and our audience for their questions and other engagement. I hope today's discussion has provided all of us with a deeper understanding of liquidated damages, and all the people who have shared their insights, we can actually use it in our professional work as well while doing our work. Thank you once again for joining us. We look forward to continuing our discussion in future sessions with us. Have a great day, everyone.
Thank you, Vivek.
Thanks
Thank you.
all.
Thank you very much. Bye-bye.
Thank you.
Bye.
Bye-bye.